India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you are regularly the editorial team's choice of the most significant stories we believe should receive close and critical scrutiny and wide circulation. You could watch them along with the visuals or listen to them as you would a podcast. In this commentary, we focus on the subject of death, on capital punishment. The subject is as old as civilization itself, endlessly debated. Recently, the capital issue, the punishment debate, took a new turn in India. The Supreme Court said that it will rationalize the sentencing process. What ails the judgment process? What is the death sentence? What is it? Why is it a dilemma for judges? A recent India Legal TV show hosted by APN TV News Editor-in-Chief Rajshri Rai sought answers to many such questions from legal luminaries. Our senior producer Sanjay Raman Sinha summarized for us the gist of all the relevant arguments. Let me recap. Recently, the Supreme Court took suo motu cognizance of the sentencing process of capital punishment. The Bench of Justice U.U. Lalit, Justice S. Ravindra Bhat and Justice P.S. Narasimha issued notice to the National Legal Services Authority and said that it will create guidelines to streamline the sentencing process. The suo motu relates to the lack of rigorous objective criteria and mechanism in the identification of mitigating circumstances. Since 1980, it has been held that by taking into account the mitigating factors, a humane and balanced judgment may be delivered for death row convicts. In the 1980 landmark judgment of the Supreme Court, that was Bachan Singh versus State of Punjab, basic jurisprudence pertaining to the death penalty was developed. It was in this case that the concept of rarest of rare crimes and mitigating aggravating factors were enunciated. Over the years, by way of several judgments, the code further developed. The current hearing has raked up the issue anew, as Justice Vimesh Shukla, former judge of the Allahabad High Court, said, "It is not the first time that the death penalty issue has been dissected by the apex court. In the 2008 Swami Shraddhanand versus Karnataka, the Supreme Court had dealt in detail about the categorization and standardization issues. It made clear that the death penalty guidelines should be issued by the government and the judiciary should refrain from defining guidelines. The issue of death penalty is a crucial emotive decision and judges refrain from taking full responsibility. The death penalty cases are often referred in appeal to the Supreme Court. Indian courts seem to be in two minds when deciding on death penalty cases. Well, note what happened in the 1982 Harbans Singh versus State of Uttar Pradesh. 3 persons were awarded the death penalty, and their appeals went before 3 different benches of the apex court. Each bench gave a different sentence. This highlights the state of contradiction and confusion that surrounds the death penalty jurisprudence in India. In 2008, a 2-judge Supreme Court bench in Swami Shraddhanand versus Karnataka was divided over confirming death penalty. This was despite the fact that both the trial court and the High Court were unanimous on the case. Later, in 1980, when the Bachan Singh case gave birth to guidelines, the matter still continued to divide the courts. Justice Vimesh Shukla, this is his opinion, says that as for the guidelines emanating from the Bachan Singh case, it is maintained by the apex court that the death sentence should be given only as an exception and not as a rule. The circumstances of the offender along with circumstances of the crime have to be taken into consideration. When a sentence of life imprisonment seems inadequate to the crime, only then a death sentence may be awarded. The aggravating and mitigating circumstances have to be balanced. The theory of rarest of rare was introduced for the first time. The categorization of heinous crimes were also done, for which death penalty may be given. Now, while hearing death sentence appeals, the Supreme Court has repeatedly expressed concern over the manner in which trial courts and high courts have carried out sentencing with very little relevant information. The Bachchan Singh decision did not detail the criteria for identifying rarest of rare. In 1983, the Supreme Court decision in Machi Singh versus State of Punjab laid down the guidelines for the application of the rarest of rare rule to specific cases. In fact, the consultation paper of the Law Commission had observed that death penalty jurisprudence is arbitrary. The panel said it is a legal lottery, and there was little to differentiate between cases in which death penalty was given and those in which life imprisonment was awarded. Dr. Surendranath, Executive Director of Project 39A of NLU, Delhi, says 39A of the National Law University gives pro bono legal aid to death row prisoners. The core issue was a collection of mitigating factors. Though in the Bachchan Singh case, the court had made it incumbent to assess both the mitigating and aggravating factors before giving judgment, no methodology was actually determined to what the mitigating factors were. But for the last 40 years or so, no effort has been made to collect mitigating circumstances. Now, the 39A had raised this issue by the way of an application in the case, and the Supreme Court took suo motu cognizance of the matter and converted it as a writ to formulate guidelines. The philosophical underpinnings of death penalty jurisprudence is quite contrary to Asian or Indian spiritual values, some believe, and the worldview which uphold the sanctity of human life and its sacred value. This is perhaps in contradiction to the Semitic teachings of eye for an eye used by Immanuel Kant to justify his doctrine of the death penalty. Senior advocate Sushil Kumar spoke emotionally. To take life is a divine function. We can't do that. In most cases which I have fought, I have given the prisoners relief. Life imprisonment is altogether a different matter, but death penalty is irreversible. If possible, we should avoid it. Now, the personal predilection of judges also affects the case. Lack of a mechanism to gather aggravating and mitigating factors is yet another problem which the judges grapple with. The 39A report has raised concerns about the quality of sentencing hearing in the trial courts, especially about non-consideration of mitigating factors by the courts. The judges may subscribe to deterrent or reformative theory subconsciously, which may reflect in their judgments. As Justice Mishra held, the judges waver between the retributive and reformative judgments. Some judges avoid death penalty and some follow the dictates of law and order and deliver according to the letter of the law. Punishment should always be commensurate with the crime, and all the mitigating factors should also be taken into consideration. Only then can the problem of capital punishment be resolved. As the debate for death penalty rages, death penalty rates have spiked. According to the Death Penalty in India report, the number of prisoners on death row in December 2021 stood at 488, the highest in 17 years. Despite the inclusion of death penalty provisions in POSCO cases, that POSCO is heinous crimes against children, crime against a girl child has not mitigated. Meanwhile, the capital punishment legal code is still evolving. Dr. Neha Mishra, Associate Professor, General Global Law School, said the Bachchan case is a landmark judgment in rationalizing the capital punishment. Here, for the first time, the concept of rarest of the rare crime was introduced. However, it is not easy to define rarest of rare. It involves lots of subjectivity. A judge's internal perception colors the definition. We need to give the definition an empirical and statistically rigorous form. If we look at the National Crime Records Bureau data in 2019, 74 death convictions were given by the trial courts. In 2021, there was a 21% increase, 144 death convictions given in 2021. In December 2021, the total number of death penalty cases stood at 488. Although there is a rise in death penalties, we do not see any decline in serious crimes. So, there does not seem to be a one-to-one relation between death penalty and crime. Second issue relates to deterrent versus reformative punishment. Also, we are yet to devise means to fathom or delineate mitigating circumstances in a convict's life. In India, deterrent theory has been best advocated in the 35th report of the Law Commission. The report had advocated the retention of death penalty. However, worldwide, the unsatisfactory field data related to deterrence has been a sore point in developing an exacting and scientific philosophy of the death penalty. As Justice Shukla said, rigorous life imprisonment is a tough punishment in itself. Extra 5 or 10 years are added to assuage the public. In the Dhananjay Chakrabarti case, much hue and cry was raised by public in Calcutta when he was awarded the death sentence in the rape of a minor girl. Dhananjay Chakrabarti's parents would also have liked a reformative sentencing. According to 354 brackets 3 of the CRPC, life imprisonment is the default punishment, while death sentence can only be imposed if specific reasons exist. This is also in the line with the Bachan Singh case directive, but the ground reality is quite contrary. Also, in 44% of the cases, the sentence was given on the day of the conviction itself. Default sentence of life imprisonment was not considered in 73% of the cases. This shows this non-serious approach of the courts. Dr. Anup Srivastava said, "We have studied death penalty cases of the last 20 years. We have found that of every 100 death penalty cases given by the trial courts, 40% get acquittal in the high courts or the Supreme Court. Another 55% cases get commuted. Only 5% death sentences get confirmed by the higher courts." It is our conclusion, and also that of the Supreme Court, that the concept of the rarest of the rare crime has been effectively nullified by a dysfunctional system which does not interpret the guidelines consistently and rigorously. Justice Shukla added, "The Supreme Court has over years taken a rather lenient view on the death sentence. By the time the case reaches the apex court, years pass and the culprit has served a lot of his time. The court then commutes the death penalty. It happens in 90% of the cases. No punishment so excites so much emotion as the death penalty. Some call it barbaric, others extol its retributive value. Proponents argue that deterrence controls crime. Adherents of reformative theory argue that it changes the criminal for the good. Professor G.S. Bajpai, Vice Chancellor, the Rajiv Gandhi National University of Law in Punjab, says that debate can't be on reformative versus retributive. We have structured our penal system in such a way that it includes both the reformative and the retributive aspects. If there is death penalty and life imprisonment provision, then the courts are wont to apply one of the two as conditions demand. Death penalty is a very individualized punishment and can't be generalized. It differs from case to case, and as long as capital punishment is in the statute books, the courts will exercise it. It should be the domain of the government to prescribe or proscribe death penalty. The Law Commission has recommended that death penalty should be prescribed for a few select cases. The fact of the matter is that there is no sentencing policy. As borne out by reports, mitigating factors are not objectively considered in the process of judgment. In the Bachchan Singh case, it was mentioned that the possibility of reform should be considered while commuting death sentence. Today, courts have no mechanism to assess the mitigating conditions, and based on their judgments, on the basis of it, like in foreign countries, there are sentencing commissions which advise the courts about the mitigating and aggravating factors of the case. Recommendations are often violated because at the trial court level such mistakes do happen. India is one of the 58 countries whose law upholds the death penalty. Despite a voluminous history of legal jurisprudence and years of code evolution, a satisfactory framework for sentencing is yet to be formulated. The current hearings, however, give heart that maybe, just maybe, some concrete guidelines may emerge which will light the path of judges who are burdened with the most existential of legal dilemmas of life versus death. This is your host, editor, Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.